Guess I'll do the computer. Okay.
Okay, so this is a meeting of the governance committee of the Newburgh IDA. This has been properly noticed. It is December 12th at 9:50. The governance committee meets at least annually to review the agency's policies. And we have a list of those policies that we'll review here today. Does agency counsel have any just kind of level setting or introduction that you want to engage in, Mr. Joe?
Certainly. So in terms of the agency policies, we did go through all of them and review just to make sure in reference to any guidance from the Authority Budgets Office, whether there needed to be any significant changes made. Based on our review, we didn't note any significant changes to any existing policies. We did find that based on a recent guidance that the ABO released, that they did mention that public authorities should make sure they have a records retention policy on hand. And so I did formalize one so that way it would be adopted and you could incorporate it into your website. But that's the only significant change with respects to ABO guidance.
Got it. Thank you so much for that and for your work on the records retention and disposition policy that we'll review today. Am I correct that the remaining policies, other than the UTEP and labor policy, which we'll discuss towards the end, there are no required or suggested amendments to any of the other policies?
That is correct.
Okay, great. So you would like to start this off with me reading the mission statement of the agency? Okay. So the mission statement of the Newburgh IDA in 2025 reads, the mission of the City of Newburgh Industrial Development Agency is to help attract and contribute to Newburgh's job opportunities, a diverse and net positive tax base to provide long-term economic prosperity and sustainability, and advance the general welfare and standard of living for the city and its residents through the promotion, development, encouragement, and assistance of commercial, technology, tourism initiatives, recreational facilities, warehousing, manufacturing, and industrial facilities, utilizing green practices and adaptive reuse where available. I think this is a smashing mission statement. And
might want to add something to separate the club, but other than that, very good wording.
I agree. I'm a fan of the semicolon. I use it regularly. So with I agree with that. I agree with that. So the substance of the mission statement, we recommend that the full agency adopt for the 2026 calendar year, and after the colon in this statement, we'll insert just stylistically semicolons in place of commas. Is that a substantive change, David, that requires any extra work on behalf of the agency?
No.
Okay. Just want to make sure. Okay, so great mission statement. We'll get some semicolons in there. We recommend this to the full board for adoption.
Yeah.
So the next item on the list are the agency bylaws. These were re-adopted at the December 2024 IDA board meeting. We have not experienced any issues with these during the course of the 2025 calendar year? Do you, okay, great. We recommend the full agency readopt those for the 2026 calendar year. We've also looked at the agency's anti-harassment policy. We have not experienced any issues with this.
Concur.
I recommend to the full board that we adopt that for the 2026 calendar year. We've also reviewed the board of directors' duties and responsibilities. Do you have any suggested amendments to this? Neither do I. We recommend this policy to the full board for readoption in the 2026 calendar year. Next, we have reviewed the agency's code of ethics. I have not encountered any issues with this code of ethics.
Concur.
Okay, we recommend the code of ethics be readopted by the full agency board in the 2026 calendar year. Next, we have the conflict of interest policy. No issues with this.
No issues.
Okay. We also recommend the board adopt the conflict of interest policy as written for the 2026 calendar year. Next, we have the freedom of information law policy. I have no issues with this policy. It's
No.
been working for the agency.
I just noticed the typo on page 2 that I'll fix under records access officer and appeals officer on the first line. Double up, I'll fix.
Oh, alright. We recommend the agency adopt the FOIL policy for the 2026 calendar year. Next, we will go to the whistleblower protection policy. We've not encountered any issues with this policy as written.
Correct.
We recommend to the full board the readoption of this policy for the 2026 calendar year. Fee structure. I'm not seeing this on the list. Does this require independent announcement?
I'd like to explain it sometimes to you all individually,
Okay, great.
but we can.
Let me set this aside for the moment, along with the agency application, while we consider the records retention and disposition policy. We appreciate agency counsel's work on this to bring the agency into compliance with best practices and what is required by the ABO. I have no issues with this records retention and disposition policy.
No issues.
We recommend adoption of this policy for the 2026 calendar year to the full agency board. Picking back up the 2025 fee structure of the agency and the agency application.
And the application Bob is going to spend a little bit more time on, so we won't discuss that today.
Okay. Great. So we will, this is, to be clear, this is not required for us to recommend for adoption.
No, is the fee structure in that resolution, David, for the housekeeping resolution?
Yes,
No, right?
no, the fee structure is a part of the housekeeping resolution.
Okay, then that's why. Yeah, so I just like to, show everyone individually, the audit finance committee look at it as well.
Okay.
So, it's $1,000 apply to the agency, and then everything else is at cost. And you can see at the bottom how we collect our fees. And I put the percentages there, because I don't have to do the math. 1/3 or half of it or something. Makes it complicated, so we all look at the exact same equation. And then on the back, there are other fees that I've never had to enforce. I've never really encountered any of those issues, but everything else is at cost. So, when a project is closing, this basically also helps clarify how the agency collects the fees. So MRB, the newspaper, we don't tack on anything to that. We just tally all that up. And then they pay that. And I'll mention what I said to the other committee, which was that, I don't have any recommendations to this, but something to perhaps discuss in the future, what other agencies do is they tack on a retainer for the attorney.
Mm,
So that way, once we receive the application, there's a built-in mechanism for them to start getting paid as soon as they're reviewing. Because if somebody applies to the agency and then has Bob and David already started reviewing it and then they revoke it, then they're chasing them for money. So some IDAs do build in a retainer as part of the application fee. And I don't think they I don't think that they would oppose that idea, but yeah, you're familiar with this.
That's a question that I guess I'm unclear on, and we don't have to discuss it now, because maybe it goes into this change of policy. So this says this is a fee at cost, suggesting that someone pays us for our attorney fees, but that's not the process that's happening, correct?
Usually it's them directly, but with the case with Brookfield, it was a little different. In that case, they were paying us, but it's just also, I guess, some people have no idea that they pay for our attorney fees. So
No, I understand. I know, sorry, not the fee itself, but the process of collecting the fees. So this is suggesting that we are billing someone for the costs.
that's the way you look at it.
Well, that's what it is. It's a fee. If this is an IDA fee structure, this is not their attorney's fee structure. But is that not how it's being collected in process?
Right now, it's
Entirely them.
entirely them, unless like it was Brookfield where we did have an account.
They're
set
right,
up.
perfect.
So it could go either way. MRB, we pay MRB. Yes, because we are the client.
Got it. Okay.
I was just telling them, Bob, that there's a different way to.
Sorry, just in the schedule, what would MRB be in terms of that?
Good question. Maybe not. Or I mean, it's not a whole harmless agreement, but yeah, maybe there isn't a specific.
Yeah, I think in planning board, we could look at just copying the link. I think it's other studies as warranted and required by the board. It's very open-ended, but maybe it's and literally dollar at cost, but.
Sorry. I will cross up and then figure it out.
Thank you.
Yeah, I was just telling them, Bob, that there is an option in the application process to collect a retainer for attorney fees.
So for our fee, Ali and Mike, and I apologize for being late. I had a conflict.
Fine.
Our fees are really in two tranches. There's agency work that is assigned to us from time to time that, I consider to be like one-offs. Cher has an issue with Belvedere Apartments. We look at that. There was the easement for the Murphy's Ditch or whatever ditch it was.
Mhm.
There was the cell tower. And those we provide the agency with a municipal reduced hourly rate. And the time is the time. If there's
And no,
resolution,
sorry, just to clarify, those are not passed on to Belvedere or I don't know who.
Those are not.
Murphy's Ditch. Okay, all right.
those are not,
Okay.
those are not. If you receive an application, once the application looks like it's going to move forward to a public hearing, what we do and what has been tradition in the state for agency counsel to do is provide a representation or engagement letter to the applicant saying that we represent the agency, but that the agency expects that they will pay our fee. And years ago, it was, here's our rates and we'll bill you at the end. And then over time, over the last maybe 20 years, it's become, here are our rates, and we want you to give us a payment up front, like a retainer that we then bill against, and you have to replenish it from time to time as we go along. And then I include, for the last 20 years, I've always included a range of estimated rates with a caveat that, it may be less, it may be more, if it's a cookie cutter, I know from experience exactly what the rate should be. If it's a little bit more involved and there's 2 or 3 public hearings and there's rounds of negotiation, obviously the rates will be more. What a lot of firms have been doing lately, and I broached this topic with the 2 of you after one of the meetings, is that they've been putting in the agency a fee schedule for your counsel, which allows really the applicant certainty as to what the fees, will be. So, upon application and public hearing, the fee is this. Upon attendance at a public hearing, the fee is, Y. Preparation of an approving resolution, preparation of closing documents, conducting of the closing. So we're happy to come up with that schedule if that's something the agency would like to entertain. It should come out the same as with everything else, but it does provide a little certainty to the applicants so that they're not. I don't think they're blindsided because the letter, and Cher can provide you a copy of the standard letter. The letter is pretty clear. Here are the fees. Here's the hourly rate. I keep the hourly rate lower than what my standard hourly rate would be for other clients because it's a municipal transaction, and we're trying to get we want the work in, but you also trying to benefit the city and the agency and trying to keep the work, keep the application going.
Yeah, I appreciate that, Bob, and I'm not suggesting at all that it shouldn't be paid for your time. I think we said that when the issue,
Right.
There was a single issue when it came up. I think we were
No,
very
and
unanimous in the
and I
fact that they
appreciate that.
should be paying you. I just want to make sure that this, like, the internal fee structure is reflective of what we are, putting out. But now that I read that, that makes sense, that there's 2 different kind of attorney fees. Some are not sent out and some are, and that's what this is
Right.
reflective of. So I think
Right.
if in the next year we can work on a clearer schedule that includes a retainer, because I think we have learned this year we should have a retainer, or you should have a retainer. Fine with that, but this now makes sense to move forward.
I would 100% concur with Ally. I think, having a retainer and having a clear schedule just benefits everybody involved, sets expectations early on. Yeah, absolutely agree with that. And if everybody's comfortable, and I think we are, something we can work on over the next year.
Yep.
Okay, great. Anything additional on the fee structure document or the application? Okay. All right, so the 2 policies we reserved to discuss last are the UTEP and the labor policy. So I'd ask agency counsel or the executive director to just go into this a little bit, like what are the considerations, what are the comments that we've gotten on these. For the UTEP, what is the timeline and remaining steps to adopt the draft UTEP that we've been working on, and anything else that the governance committee may need to know before we recommend to the full board.
I'll just say really quick, Bob, just a tiny thing. So we did, usually the UTEP is a audit finance committee thing, but because we did review this as an entire board and have a public hearing, I kind of advised that committee that, the board had already had a discussion, so there were no comments from them aspect, but I'm reviewing it again here, since it was an entire board discussion, that this committee then could also have the same opportunity as the previous one did. So we did have a public hearing, and I want to say that was in September, and there were no public comments that I can remember. That was recorded, that was up on the website. So at this point, unless, you know, Bob has anything else to recommend, I think we just have the draft as unless there is something that conflicts with the labor policy in any way. So I would leave it up to you.
I mean, on the UTEP, I agree. You know, you consulted with MRB, you've gone through a couple of drafts. Very deliberative process, public process, open to the public. You asked for public comments. The UTEP is, in my opinion, is ready to be approved. Can be approved on Monday night, can be approved next month. You know, the question for Monday is metal-wise, if that goes forward, what UTEP is that going to be under? So we need to make that very clear to them. But there would still be a deviation, I think, even for this one. So we may want to maybe do the UTEP in January and be very clear going forward that this is it. No more deviations. This
Are
is
there other projects in the pipeline?
Right, and so 191 as well, since you have an approving resolution for them on Monday, which
no. So 191, I would take the position we've already, you know, we've already done everything for them with respect
Under the
to
old,
with the well, and we did a deviation hearing last month.
right,
So
right, okay.
so their 191, the approving resolution has already been passed through the public hearing. You sent the deviation notice out to the taxing jurisdictions. I think 191 is fine. I think the two in the pipeline are the taco place, right? Which may or may not, I think they actually signed our engagement letter finally. But I don't think they have a complete application. And then the second one is the project that is on the waterfront that I think you guys had a discussion on, Mike, with the developer, that I don't think we have an application yet.
my only question, Bob, is that for 191, the scenario that we brought up was that the sales and the mortgage tax needed to be reflective of the old UTEP, consistent, that it would be inconsistent with the new one. So that was. Remember that conversation that we had?
I do now, so let me take a look at that this
Is
afternoon.
that in general though? I mean, is that an issue that we found?
So, because the new UTEP disregards.
No, I understand, that's what I'm saying, so is that something, like, we didn't think about that, I think when 191 came up, we all kind of said, oh, right, fair enough, no one else, oh, right, there is not a mechanism for the city council to offer that. Is that something we want to discuss in adding to the UTEP, that in instances where they have this joint application, can the IDA consider both for the mortgage recording and sales tax, the entire project? Again, there is not another entity that could provide it. It's maybe that goes to the whole board to say, do we want to consider that? And that delays it till January anyway?
Well, do we have statutory authority to grant those for the entire, can you refresh my recollection here?
Right. So the three forms of financial assistance you can provide by statute are sales, mortgage recording exemptions, and a pilot. So the UTEP, you know, the legal analysis is the UTEP should technically only be regarding the pilot, but because of the vagueness of the statute, I think all of us that do this work have always included a sales and mortgage recording tax provision in the UTEP as the additional part of the financial assistance. But it's in, Mike, it's in the statute. So it's whether it's in the UTEP or not, you have the absolute authority to grant it.
Without a deviation? if they followed, if there was no other deviation and they wanted that, could we provide it?
So yes, because you really can't deviate on the mortgage recording tax or the sales tax. It is what it is. The sales tax is 8 and I can't remember if it's 8% or 8.25.
175.
And you know, the exemption is the exemption. You follow the state tax finance forms, the ST60, the ST340 annual form. The exemption is granted. The mortgage recording tax, it's not a straight 1% in Orange County because you're in a transportation district or transportation corporation area. So therefore it's 0.7. They can get up to 0.7. If you grant mortgage recording tax exemption, they get 0.7 off. They have to pay the balance. So there really is no deviation on those two. The only deviation is the pilot. And the idea is that you have your pilot in your UTEP. And if you're deviating from that, then you need to give notice to the taxing jurisdictions. I've never been in a situation where an agency says, and I guess to answer your question, you could say that you're going to reserve the right to give less than the full sales tax exemption, but I've never had an agency really consider that. Does that make
So
sense? Am I answering?
It does, it does. So if the board were to consider adopting this UTEP on Monday, would it make sense to just put it towards the end of the agenda so we can process 191 and consider Metalwise?
Right. And I think you would do that. It's an effective date of January 1.
Okay, that makes sense.
And like all conversations I've had, which are not formal, but with Hudson Taco and the Benora project, are that they should be reading the new UTEP. So, I think they're both commercial projects and they're both expected to.
Right. I think Benoro, that's absolutely the right approach with the Taco project.
They signed an engagement, maybe.
I mean, they do have an engagement letter. They have submitted an application. It's not a complete application. I think they paid the application fee, right, Cher?
It did.
Yeah. So
It's
could.
entirely a commercial project though, so
It is.
they may choose to, I think that the new UTEP is more beneficial to them.
Right. That's a good point. That's a good point. Right.
I don't remember what they asked for, but I don't remember having a conversation with her saying, here's the new UTEP. Maybe you did.
I did, yeah, I said, please, I said, we are looking to adopt this, you should be reviewing that.
Okay.
Which is maybe
So
why no one followed up, maybe they hate it so much, but.
I mean, ostensibly, the new UTEP should really benefit mixed-use projects because they're not subject to the closing costs in the residential portion.
Exactly right. Exactly right.
Yeah, the feedback we got from the Benora project is they were happy to, if they apply under the new UTEP. And again, I didn't get direct feedback, but the Hudson Taco project is entirely commercial, and so it makes the new UTEP is probably more beneficial to them.
Great. So we are in a position to adopt this on Monday night, effective 1/1.
I think that's right.
Great.
We'll get a resolution to that effect.
Fantastic.
It has to be a separate one than the housekeeping.
It should be because it's a change and you've gone through the adoption.
And I know that it's a pretty tight turnaround. If it makes more sense to do in January, that.
We'll get you the resolution this afternoon. That won't be a problem.
Amazing. Amazing. I know we have the right one. Okay, and then the last item on the policy list is the local labor policy. This is something that we've uh been looking at throughout the second half of this year. We've had some contact from local labor representatives about some aspects of this policy that they feel aren't quite working for them generally, and then on specific projects. We've also had requests from representatives of local labor for waivers of this policy on existing projects. And in the context of the new UTEP, I think there are some other considerations that would activate around this local labor policy. Sarah, is that a good summary of where we're at? I don't know if we have, if we want to discuss specific feedback that we've gotten on this policy.
One particular thing is the 85-15% split. It's like it could be clearer in the policy what that means. So 85-15 just means the entire project. And the subs and the unions are interpreting it as each.
Yeah, I think in the on the second, I don't have it in front of me, but on the second page of the policy, I believe it is, there's the 85%, the general, and there's a statement that's to the effect, the general contractor is responsible. And then there's a comma and language that can be implied that it also 85% also applies to the subs. And I think that's probably just poor drafting. The 85%, I believe, has always been intended to mean for the totality of the project. Because there are some subs that you want to utilize, but they're local, so you want to use them, but they may be 1 or 2 man shops. And for them to then be under an 85% burden of having to also have local labor may just be burdensome and kind of cut them out. I don't think that was the intent. The intent was that on the totality of the project, the general contractor is responsible to have 85% local labor. And if he can't get it for certain aspects, then there's the waiver process, which I don't think is overly burdensome. And especially with Loki Brill, they're pretty good at saying, yes, this is a proper request, or no, this is an improper request because there's plenty of local labor that's available for this particular job.
Right, and so that was one of the concerns for the carpenters union in their letter in the first bullet point. They're concerned that the contractor RC Anderson will take away the entire carpentry package to somebody else because they're getting that 85 someplace else. So it's just a question for you all, like, which way do you want to go with it?
I can see how the language is like on page 2 is a little confusing, but I completely agree with Bob, and I think we have to stick with this. In this one, it's frustrating because it's carpenters and we have carpenters, but we've had, specialized European component, and you need to bring that entire team in to do that. That's the point of the 15. Then you have to have more. You have to have all your carpenters local. I don't, what the split is not for the board to decide. It's for the GC and the project to decide. This is personally frustrating because I know union carpenters who are unemployed in Newburgh right now, and they could have done it, but that's how it goes sometimes.
And that's all I need is perfect.
I think if we change it, we don't have too many other vendors as possible. And it has specialty in how country or state where we're doing. So,
So I mean, I think we need to clean up that sentence,
yes, I can see.
you know, and we can circulate a red line of that this afternoon. And provide that, we can discuss that on Monday, but I think otherwise, unless there's other letters that have been received, I mean, I know that Matt Stoddard has been before you a couple of times saying that he thinks it's a great policy. So
And it also mirrors, it mirrors the state's MWBE too, right? Where it's the whole project. If you make it easy on yourself by having one of your firms be an MWBE, it solves your whole problem. You don't have to go individually. It's done.
I have received some informal specific feedback on Exhibit B of the policy. Particularly as it relates to the OSHA 30 training and the drug screening.
Yeah.
You know, I think from the feedback I got from a leader, a labor leader, is that the standard now is OSHA 10. I haven't independently verified whether that's true or not. Or that my understanding of that feedback is correct. And I know that the drug screening policy can be onerous in 2025, given the legalization of medical marijuana. So I think Exhibit B might be something that we want to take a look at in the next year. And I think even just, you know, continuing to solicit and elicit informal feedback from labor leaders is a good approach as we monitor whether this policy continues to work for everybody involved. But just wanted to add that into the record.
we can probably, I mean, I could probably get an answer on OSHA 10 or 30 by Monday morning. I'll ask one of the labor guys here quickly about that. On the drug screening, you're absolutely right. With legalization, I mean, we deal with that at the firehouse all the time, because the young people are like, well, you know, I can smoke and drive, and it's like, no, you can't smoke and drive. But, you know, it's
I would rather everyone sober every day than have a marijuana test from a month ago come back positive.
yeah, it's you know, driving a 40,000-pound vehicle is not under the influence is not what we want you to do. So, but you know, same thing with operating power tools. It's a protection of the job site, it's a protection of the individual. But I can follow up. That's going to take a little bit more time, I think, to consider that part of it. But I can do some investigation on that. But the OSHA 10 or 30, I'll take a look at. We'll get an answer on that by Monday.
Okay, great. And, you know, obviously goes without saying, and everybody's right on it. Priority is always personal safety, safety of everybody at the work site. And, you know, this agency will never weaken worker protections.
Right.
Yeah, I mean, maybe just having requirement that every contractor and subcontractor has a drug and alcohol policy, something like, you know, I don't know if that's too weak. But again, for me, it's the concern of someone inebriated right now, as opposed to the drug test showing up that what they did all week.
Well, and also you see the letter from Loki.
Exactly, yeah, then it is expensive. We do them here, so.
It's expensive, and that in their experience that they've almost never come into that issue. And, you know, they would report that if they saw it.
Which to me suggests they have a policy, so. Just that, if you just have everyone, it's not hard to.
No,
get
we'll chat with
policy.
them, maybe share, we can
Okay.
chat with them, or you can chat with them, that, they do this, review all around the state.
Mhm.
And maybe we can get an idea of if the standard has changed a little bit, but I think, Ally, that's an interesting alternative if they just have a policy. I think it would be malpractice on their part if they don't have a policy in 2026. It's not 1986 anymore, so.
So we'll do a little extra backgrounding on this.
Yep.
And then we'll revisit over the weekend before Monday, and then, if additional work needs to be done, I don't think these are paradigm shifting items, and, if what we need to do is just recommend adoption of this policy with the minor changes that we've already discussed, and then revisit Exhibit B items in 2026, I think that's a.
Yeah, and I just want to know that I really like the apprenticeship clause. I know that there's been concerns about it, but I don't think it's that complicated. We have many projects in the city of Newburgh that do them internally, and they just set up the program. It's not outside. It doesn't have to be outside. It doesn't say it has to be outside. It doesn't say it has to be a union apprenticeship program. And I think for the general Newburgh public, when they think of local hiring, that's what they think of, is hiring someone who wouldn't get a shot otherwise. And so if we're saying you need a apprentice, I just don't think that they're getting a lot of money from us. And
Yeah.
that's just how I feel about the apprenticeship. Carney does it internally. I know that Keith Leibel does it internally. Keith Leibel at least is small, like he's a small guy. And he does it out of the goodness of his heart. And if he can make it work, I think that it's,
Yeah.
he's at the bottom. Well, but Carney does it too, so it's not, I just don't. You don't want to do it, but then you can partner with a union.
I mean, the apprenticeship is just the right thing to do. I
Yeah,
mean,
that's how I feel.
there are young people that, this is their path, and
Or it's
they-
not, and then you hire them for a month and they fail, and you're still
right.
fulfilling the requirement. We're not saying you have to keep them on full time. We're saying you have to.
Right, and I think that Matt started, if you go back in some of the minutes, I think
Mhm.
that's the part of the policy that he embraces more than anything else, and has asked other agencies to take a look at your apprenticeship project, piece, and adopt that, because he thinks it's so beneficial to his guys. So.
And Matt is, I mean, he's a Newburgh guy. He graduated from NFA. He really understands how a policy like this translates to the workforce locally here. So I think that's really important feedback. And totally agree. This is the commitment that we want from people who want to invest in Newburgh. We're not just taking anybody's project or anybody's money. We want a commitment to the local workforce. And, I think we've received some individual feedback about the related costs of having an apprenticeship program, but I think it is also worth pointing out that many of the projects that we're going to be getting here are mixed use, and bifurcating, those parts of each project have now reduced dramatically the closing costs for folks who seek IDA assistance. So I think that I agree with Bob and Ally that it is the right thing to do, and it just makes sense.
Can I just bring up some other points? Something else the labor union brought up was the clawbacks when the contractor doesn't comply with or in their words, kind of like can find ways around things, right? So like if they don't do the 85-15 split, oh, we're gonna use these non-local guys because we're gonna use local this time. And then it turns out, oh, sorry, like, this didn't work out that way. I have no idea how to answer that, but like what repercussions would there be for them? I mean, we employ Loki Brill to check up on that, but at the end of the project, if it's not an 18-15 split, like what do IDAs do then when they didn't follow policy in that way?
Yeah, I mean, that's a great question. If the project's already been completed, under your closing documents, the only power that you have is to declare a default and then claw back all of the financial assistance that's been provided. Write a letter for the sales tax, which is your only obligation on that. Write a letter on the mortgage recording tax, and then cancel the pilot to the extent there is any. I've never had that. Well, I've had that clawback happen once in the town of Montgomery, where the company just closed down. There was no pilot, and they sent a check for the sales and mortgage recording tax with one letter, which was pretty amazing. But they just, they decided to close the plant and for business reasons. And yes, things changed, and yes, you're entitled to get this money back. I think at that point, hopefully we've had discussions with the company before you get to that point, while the project is ongoing. And then it will be a very hard question for the agency. Do you cancel everything because they're at 80% as opposed to 85? If they're at 20%, I think the answer is pretty simple. But again, if it's a project that is really, really important and your clawback negatively impacts the project for the next 20 years, it's a really facts and circumstance tough position to be in. Hopefully, Loki Brill doesn't allow it to get to that point. And if the applicant, the company is not listening and following the local labor policy, the time to act is really at the beginning. Get them before the agency at a public meeting, explain to us why you're not complying with a contract that you signed at the providing of the financial assistance. Provide us with the reasons, and provide us with the reason why we should not terminate and claw back everything that you've been provided, and have that in a public setting where they have to present, and then hopefully makes your determination pretty simple at that point. So it should never be, it shouldn't be left to the end. I guess is my message.
I think it also negates Loki Brill's second comment, which is that the certified payroll collection is overly burdensome, because if we're not getting, maybe it does defend it. I don't know, but I work in a field where we use certified payroll for everything, and that therefore we know the issues right away before we've paid money.
Right.
But maybe what they're saying in their last sentence, they're falling behind and it's falling at the end. Maybe they are not finding out some of this information until the end. They're blaming it here on certified payroll. I don't know whether that's accurate or not, but.
Yeah, I'm not sure about that, but I think if there are Loki Brill has to, they're getting paid a lot of money by the applicant.
Right.
But they're fulfilling your mission under the policy. If they're not getting cooperation, then I think it compels the agency to pull the company in at a public meeting and say, what's the problem? Tell us what the issue is. We'll work with you. We'll figure it, but tell us publicly why you can't follow this policy, which you were aware of when you applied, which you was confirmed when you closed on the financial assistance, and which you somehow are refusing to abide by today. And we're prepared to cancel the financial assistance if you don't provide us with the right answers.
Yeah, and I just feel like the ongoing certified payroll is the only way we have to guarantee that that worker is the one who was there, and that's how we, are very
Right.
close to 85, or we're well over 85, or whatever it is.
Yeah, I mean, I've heard the defense of payroll records are burdensome. They really shouldn't be.
Well, yes, I have this on a small scale using HUD funds, because HUD funds require you to use a different form of federal certified payroll, and they make it like tiny Newburgh plumbers make it work. So
Yeah, I mean, it's
mm.
at the end of the day, it's math. It's record keeping and math. I mean, it's not. I don't understand.
And these are large projects, right? I mean, this is not, again, fixing a water leak in someone's basement, which is what mine are, and I can still make them follow the instructions.
Yeah, these are large
I-
projects that have
I-
consultants that have multiple spreadsheets
Right.
and are proficient in Excel and proficient in, whatever that Gantt chart program is. And I mean, that they can figure out the expenses down to a penny. Well, we don't have pennies anymore, but down to a nickel. And to me, that's never an explanation.
Okay.
Or defensive explanation.
And, I think there's like a sliding scale here, right? Like if you're at 80%, there's maybe a finding of fact where it's like you determine, okay, there was a reasonable good faith effort to comply with the 85%, right? If you're at like 20 or 30%, for me, that's almost like strict liability, right? This is just willful non-compliance at that point, and there's a more pointed conversation to be had, and some real accountability.
Just a clarifying question on that. So it would require a board action, meaning a public action, to claw back, correct?
It would require a board action. You couldn't
Okay.
do it on your own.
Okay,
But,
so that's, I'm more comfortable
But
anyway, right?
ideally, what I've always recommended to agencies is to pull the company in beforehand,
Understood,
have a
yeah,
frank conversation behind closed doors and say, what gives? Why, do you really want us to claw this back? Do you really want us, to pull you before a public board with public people now watching on TV, video, whatever, and have you in an uncomfortable position of explaining why you can't comply with a policy that you knew was in existence before you even applied?
Yeah. Agree.
And fortunately, because local labor policies have been in effect now for at least a decade, there's been very rare instances of just willful non-compliance. I'm just not going to comply. Come after me. I don't care. I think there was one in Suffolk County, and I think it was the town of Riverhead, and they just let it. They just bailed on it. They said, "Okay, we're not going to do anything," which was the wrong, in my opinion, the wrong response. But it's Riverhead, so maybe who cares? But
So can I just review? I just want to refresh because there was two different sets of comments. So with the apprenticeship program, that's gonna stay. Certified payroll is going to stay. The drug testing, we're going to talk to Luke Brill and ask if it's a standard policy for a drug policy. And in that case, if they do, we might consider removing that part from our exhibit B. Okay. They can
posted 10 versus 30, which we'll see clarification on.
Correct, and that may change. And then regarding the 85-15 split, we're clear that that is for the entire project. That is not for phases or for each individual subcontractor, which then answers some of these other questions that I had, the local labor. Yeah, and the apprenticeship stays, and how is it enforced? Well, we pay, or a labor monitor is paid, and they just have to do their job. Pretty simply, they have to do their job to enforce or to oversee.
We are requiring certified payroll. I think that's part of it. Require certified payroll, and we require local drill to review says certified payroll.
Right, and if they should patch it before it gets to a point where it's like, it's not the end of the project, whoops. And if it does happen, then we bring in the developer to explain, and then there'll be a process for that. But the agency, from what I'm understanding here, isn't in the position to nitpick over the GC for each individual relationship that they have with each subcontractor as far as what's going on, because that was kind of the questions I was being asked is like, how do we ensure all of these things? Well, we don't. It's like we hire a labor monitor and they're the ones that ensure that what's in the policy is put in place. So, okay, I just want to be clear on that.
My only clarification on that statement,
Yes,
that you are reviewing, you are certifying, you're just engaging a consultant to help you in that compliance. So it's
correct, because they
the
do send the
agency.
reports at the end of the month as well.
Right, but it's the agency's responsibility. You're just engaging the consultant to help you because it's outside of our area of expertise. It's their area of expertise.
Understood.
You can't offload, and I think you all know that, you can't offload the agency responsibility to locally Brill. Ultimately, it's yours. You monitor your policy, you implement your policy, you're asking them to help you do that.
Okay. So, and I just want to say, we are required to review the policy, but we're not required to readopt the policy, right? Like, if
So the statute says, and the ABO recommends that you do an annual review of the policy. And I think we've taken the approach for the last, I've taken the approach for the last 20 years, that by doing a housekeeping annual resolution, you're acknowledging that you've reviewed the policy and the policy is essentially being readopted for the following year. But the statute does not technically say that you have to adopt the policy on an annual basis. It says you have to review the policy.
So I just say that to say, like, if we wanted to, technically, we could still keep this version. We reviewed it, but we could officially readopt it at another time.
Absolutely,
Right.
absolutely, absolutely.
Just so you know, we have that flexibility.
All right, is there,
You can review the policy at any time. You can change any policy at any time.
all right, are there any other items on the agenda that I have missed or have been added since this was published? Okay,
We were given a copy of the application.
Yeah, but they're gonna review it in January.
Well, I'm sorry, I thought you meant we just had to wait today until PK, I'm sorry, I misunderstood your original comment. Sorry.
all right, if there are no other items, I suppose this meeting is over. All in favor? Aye.
Right.
Thank you so much, Bob and David.
We'll see you Monday.